David, who's here for the applicants?
I'm here for Dorado.
What's your name?
Lee Teely.
T-E-A-L-Y?
Thiele.
Just take my application.
Yep. I swear by Almighty God that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
What agency are you from?
YPA, Werribee.
You did also get your resignation.
I swear by Almighty God that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Your name?
David.
So this was requested to be heard by me. Can you just refresh my memory about what?
Yeah, sure. We had a VCAT hearing on the 8th of January in Werribee.
Yes.
There was an order that the tenant had agreed to move out of the property. It was mutual consent. There was an issue with the paid to date on the order stating that the rent was paid to the 2nd of January because the tenant produced a receipt, but we don't have the money. It hasn't showed up in our trust account, and I didn't say that on the day, but because the tenant had a receipt, it had gone through as paid to the 2nd of January. But I'm guessing perhaps the funds may have dishonoured back into Mr Keenan's account, and we haven't received them. So the paid to date is incorrect.
Have you got the order?
Yeah. Do you want me to bring it up? Yeah.
And I made the order, we did it by, oh yes, we did it by consent, I said. But that was based on,
I was disputing the rent and saying, was advising that we hadn't received it. I spoke to Mr Keenan after the hearing and asked if he could bring in a statement that shows the funds going into our account and not bouncing back, which he hasn't done as of yet. So I've got a copy of our trust account ledger here, that we haven't got the funds. So
if you could bring that up.
yeah, sure. Because the receipt that Mr Keenan produced, you couldn't see some of the bank details for our trust account, crossed out for privacy reasons, I guess with his banking. So I don't know whether there may have been an incorrect digit put in, or I'm not sure what's happened there. But Mr Keenan...
The date when it was supposed to have been...
what date did you pay
It was
it?
paid by EFT on the 23rd of December 2015.
So I have highlighted the payments that we have received for the same amount as Mr Keenan paid, but they've come through with different property references because they are for our other properties.
What was the amount supposed to be?
$1,456.
So what was it? What are the, because there's a number of highlights on here. What's the pink highlight?
Oh, that's just our own banking there. So I think it's in the orange colour. They're just the payments we've received for the same amount that Mr Keenan claims that he paid, but you can see that they are for other properties. Mr Keenan's...
Oh, it actually shows the property on here. Is that?
Yeah, well, the tenants are required to put in a code so we know whose rent it is. So HAML8 for 8 Hamlet, which is the property address, would have been the reference that Mr Keenan claims
Are there other
paid through.
Are there other paid amounts for that?
No, we haven't got any on those statements for 8 Hamlet.
Did I see the other? So what's Cole 20?
So that will be 20 Colby, a different property that we manage.
And then Milo 11 is a bit similar.
Yes.
I see. Right, just give me so he says the 23rd, so I'd expect them to see it on the same day or a few days later.
Yeah, I just thought maybe because of the Christmas break it might have taken a bit longer, but I've gone through I think to the 14th of January and there's nothing.
Well, there's nothing on here up to the 31st of December. So are you saying that amount was paid out?
Respectfully, Member Bent, we can't have the hearing over again. It's a fundamental principle of law. There's no mistake in the order. Without being patronising, it's extremely well worded. This is exactly what occurred. I understand the position of the applicant, but short of a review process or a formal appeal process, and I honestly don't know whether that's possible in these matters, but we simply can't have the hearing over again. On that day, on the 8th of January, I provided a bank statement, I provided receipts, and I don't think there's any suggestion by either party that there was an impropriety or something like that. You examined the evidence, and the evidence was favourable to one party, and really that's the end of it. I can't see how we can have the hearing over again.
Well, two answers to that. Number one,
It's going to be the same evidence, and
I haven't made any findings. There are no findings made by me on the evidence.
respectfully, Member, it says the tribunal find that. In number 3, the rent, which is $14.56 per calendar month, is paid to the 2nd of January 2016, which is correct. And the rent owed to today's date is $287.22. It's absolutely correct.
And Mr Keenan didn't provide a bank statement, he provided just a receipt.
I provided it, I've still got it here, it's attached to the receipt itself. Respectfully, Member, it's going to open a can of worms that can never be shut if the tribunals and courts rehear matters over and over. I can't see how it can occur.
Well, this was a possession application, not an application for compensation and bond.
The only new issue or claim today is with regard to locks and keys. That's the only new one. But on the 8th of January, you comprehensively calculated how much was paid to the 8th of January. You even went so far as to calculate how much would need to be paid if I left on the 11th of January, which I did. You made the point that you can't put that in the order because it's future dated, which makes sense. But you were very comprehensive regarding the applicant's claims for rent against bond.
What happened?
Where did you move out of the property?
On the 12th of January. So I applied then to the tribunal for bond and compensation, so for payment of the rent, which is still outstanding, and for the change of locks because Mr. Keenan refused to return the keys. He advised me he'd vacated, but he wasn't returning the keys to me.
I suggest we can get to that because...
No, can you not interrupt?
Oh, sorry.
Yeah, Mr. Keenan refused to return the keys. He did advise in writing that he had vacated, so we had the locks changed.
And that was on the 12th?
That was on the 12th, yeah. The order was that Mr. Keenan was to vacate on the 11th. Didn't receive anything by close of business, so I contacted him on the 12th, in which he texted me to say that he'd vacated the property.
Do you want to bring me your other evidence then about
Yeah.
the other things, replacement of garage remotes and the change of law? Got bond receipt 39. Text messages about keys not having been returned. Receipt. So the receipt for City West locksmiths, so you've broken this down into, have you?
Yeah, so it's for the replacement of the garage remotes and rekeying the property.
So you didn't get the keys back?
No.
Is there anything else you wanted to tell me?
No, I think it's all there.
What did you want to tell me about the keys and the garage remote?
Member, after being before you on the 8th of January, I met with the applicant, Ms Steele, and we made an agreement, and that agreement was to meet at the premises at 5 p.m. on Monday the 11th of January 2016 for various purposes, including return of the keys. And I trusted her, I believed in what she said, and I waited there between 5 p.m. and 7 p.m. and she was a no-show. So I offered the keys at that time, amongst other things. I also I had the cash available with me to pay some of these sums which have since been paid anyway. I texted her the next day and I didn't get a positive response from her. I wrote to her to try and finalise all matters so that we didn't have to be back at the tribunal here, but it amounted to nothing. I've had no word about the condition or how they reviewed the condition of the premises. There's just been no response. I think their intention was always to do that.
They haven't made any allegations about the condition of the premises.
What I'm saying is that I've just had absolutely no response with regard to that. I understand that there are no claims in that respect, but so it was a situation where the applicant acted unilaterally without any warning. The applicant acted hastily because it was the day after I texted her to try and finalise matters that they decided to change the locks in the place. So there was an obligation there to mitigate any loss or damage, and they simply didn't communicate what they were going to do. The particular circumstances in which I left the premises was that because of the notice period, which was short, and because of the timing of the notice period, which is just before Christmas, I reached a point on the 11th of January where I just had to simply put all my belongings into storage. And that left me with one option, was to travel about 100 kilometres away to seek accommodation at that time, which was available. So I was in a position where I couldn't lock the keys in the premises when I left. The applicant was a no-show. The locks required locking from the outside, so you can't lock the keys in. I had the keys. I had a place to stay that night, which was over 100 kilometres away, and that's why I texted the applicant the next day and I wrote to the applicant by letter and didn't get a response. So I took all reasonable steps.
May I answer?
You need to respond.
I took all reasonable steps in all circumstances, but the applicant didn't want to accept the keys, and in so doing, the applicant was actually consenting, not forever, but in the short term, for me to keep those keys until we could organise to get them back to the applicant.
Where's the text message where they say, I consent to the keys being kept by you?
It was a constructive consent because we made an arrangement, we had an agreement, and it was the most practical and logical way to do things because it would have solved all outstanding issues, and the applicant was a no-show.
What about, they've asked you to please advise where the keys have been left and you haven't?
As I said, I couldn't, because the locks are required to be locked from the outside. I was in a position at 7 p.m. on the 11th of January when I left that I couldn't leave the keys in the property unless I left it unlocked, and in all circumstances I was only able to gain short-term accommodation some 100 kilometres away.
Why didn't you just drop the keys into the real estate agent's office on Tuesday?
Because I was 100 kilometres away, and I was happy to meet the applicant at any time. I just wanted to make sure they were going to accept the keys. I didn't want to travel 200 kilometres round trip, only to find that, no, we don't want to accept the keys today either.
Well, presumably the real estate office would be open from 9 to 5.
Yeah. I contacted the applicant the next day to make a firm arrangement, so there was no loose ends and false claims about non-payment or whatever.
Well, other texts or anything you want to show me?
Me?
What is the letter sent from 22? Oh, okay, so it's the letter you're referring to.
Yes.
Have you seen this?
No, I've not received any letters.
Well, I'll show you this and drop it.
Sorry, David, did you post the letter or drop the
Yes,
letter in? Or
I posted.
Okay.
If you want to ask him some questions, you can ask him in your reply.
Okay.
You've got that right at cross-examination if you want, but just let me work through this. Is there anything else you want to say, Mr. King?
I don't think so, thank you.
Well, I've got a question to you. Do you have with you that receipt that was, you say was entered last year?
Yes, I've got two.
Do you have your bank statement with you?
Yes, it's attached.
And you're under oath as well. Did you actually pay this money?
Yes.
Or what?
I don't know the answer to that. My bank says that it's been processed.
Bring it up. You've seen this, presumably.
I've only seen the receipt for the actual payment that was made. I haven't seen any statements or anything else. And the receipt, yeah, that I saw on the day that you cast.
Oh, you can see them. I've seen them.
Okay, so again, that's not an actual bank statement. That's something that Mr. King's done up there.
No, it's a download. It's the CSV file.
Well, there's no banking header or anything on there. I mean, that shows me that that's sufficient proof. And I've asked Mr Keenan several times if he could please bring me a receipt. He hasn't done it. That's yours. May I? Mr Keenan and I never agreed to meet on that day and that time. After the hearing on the 8th, Mr Keenan actually approached me when I was at the service station filling up my car and requested to meet with me on the Monday. And I told him I'd have to check my calendar. I don't know what my availability is. I called him later that afternoon, advised that the owner wanted to attend the final inspection, and we've got 14 days to get that sorted, and Mr Keenan had to close the business to return the keys, in which he refused unless I would meet him at the property with the bond form.
Can you go back a minute, because that was all quite fast forward.
Okay, so Mr.
So you say you never agreed to meet him at 5 p.m. at the property on that day?
Yes, that's correct. I spoke to him on the phone the same day, and I said the owner wants to have a look through the property before he can give me approval to release the bond. So I don't have to meet with him on Monday. I tried to explain he has till the end of business to return his keys as per the court order, and he refused unless I would meet him at the property on the 11th with the bond form. I explained to Mr Keenan we do have 14 days to finalise the bond. The rent issue was still outstanding, and until he could provide me with sufficient evidence that the money was paid, the bond would not be being released on the 11th. And also I didn't feel comfortable meeting him at the property, considering he was at the service station when I was there. So there was no agreement to meet on that day. There was no time made. It was quite a heated discussion over the phone, which I was verbally attacked by Mr Keenan, and advised him that if he didn't return his keys on the 11th, then I'd be proceeding with the possession order, which was granted on the 6th. But that's when the text message said that he'd vacated, and I just got the locks changed. And that's the last contact I've had from Mr Keenan. I don't have any other text messages.
So you
I haven't
didn't
got
receive anything back in response to this?
No.
Please advise how I can get the keys back.
No, I've got no emails. Mr Keenan's got my email address. I've asked him several times. I've emailed him with no response, and I haven't received this letter.
Is that all?
Yeah, I think so, yeah.
terms of the issue about when possession was given up, and there's conflicting evidence about that. Mr. Keenan says that there was a meeting arranged at 5 p.m. on the 11th. The property, the real estate agent denies that and says there was no such meeting. And she contacted Mr. Keenan by phone to try and put back the keys in possession of the property. The only objective evidence I have about what in fact occurred, I print out text messages between those two parties. One in which, on the 12th of January, from real estate agent to Mr. Keenan, saying, please confirm that you've vacated the property, please advise that the keys have been left. Thanks. And there's a response email, I confirm that I've vacated that property, please advise the time and date for a final inspection. And then there's a response email from the real estate agent, legally you have not vacated and still in possession of the property until I have the keys. Please advise how I can get the keys back. You are also liable for rent until YPA has the keys. Thanks. So that's the objective evidence. The only other piece of evidence I have is a letter that Mr. Keenan says that he sent to the real estate agent. That's dated towards the end of January, so almost 2 weeks after these series of text messages were received. And on the evidence, there was no responsive text message or any emails or anything alike to this question that the real estate agent sent to Mr. Keenan. He hasn't provided any text messages of his own or emails of his own in response. So based on the objective evidence, it appears to me that the real estate agent's version of events is the correct one, and possession had not been surrendered on the 11th. The 12th indeed, because the keys hadn't been handed back, which means that Mr. Keenan's liable to the rent up to and including that day, and the amount for the keys and the remote, all those amounts. The other issue though is about this rent, and the problem with this is that there's already been a factual finding made, and there's been an order that's been made by consent about it already. That's the issue, so I can't really do anything about it.
So can I apply for a review hearing on that hearing?
Well, you can't, because both people turned up. That's the problem.
But I disputed on the day that the rent was paid. I didn't accept the evidence. I know obviously it's been put into the order, but my landlord's now out of pocket over $1,000, which he relies on the rent for the mortgage payments, and it just doesn't, it's not fair for the owner. And I've asked Mr. Keenan so many times to please bring me a receipt, please bring me a bank statement. I've spoken to him on the phone. He's failed to do so. So I just can't see how the rent has been paid if we've received every other payment in the past, why this one wouldn't have gone through, and why the statement that Mr. Keenan has bought it looks like it's an Excel spreadsheet. It doesn't look like a statement. It doesn't have the same print on the bottom as the receipt does to say it's been printed from online. It just doesn't add up. I suppose my main concern from all of this is, if tenants, can they just start photocopying receipts and bringing them in, and that's going to count as evidence? I'm not saying Mr. Keenan's done that, but it if an agent will dispute it and with proof of a trust account statement, it's it's just quite concerning from a landlord's perspective.
I understand the issue, but the problem is that the orders have been made by consent. Other than order 4, which was about 5980, they're consent orders.
It was consent for Mr. Keenan to vacate, but I didn't consent to the rent.
Well, according to the order I've made, you have. But by consent other than for order 4, the other 3 orders were by consent orders. I mean, that's the issue.
Oh, if it is what it is, I guess. It's just frustrating for the owner.
I can understand your sympathy because I sympathise with the position that you're in, but I mean, it is by consent. That's the order that's been made by consent.
But because we're here today on the same matter and the evidence given, I mean, in my opinion, is not sufficient.
But the whole point is you can't have. The point is there's finality in litigation, so if there's issues that have already been determined by consent of the parties, you can't just keep litigating. If it hadn't been made by consent, then it might be a different matter. We'd still be potentially working out the compensation today, but it's a consent order.
So that means that the owner can't even go through insurance either to claim his loss of rent. He's just...
I just don't think legally there's anything I can do about it now because it's been done by consent. Other than that 5980 reimbursement of application fees, the rest of it's been done by consent.
It is what it is, I guess.
Yeah, I mean, legally I just don't think I can do anything about it. I understand the position you're in, but
I'll obviously, I need to explain it to the owner. He's aware of what's happening. I'll have a look into it and I'll see what options there are, if there is any for him. But I mean, if it's legislated and that's the way it is,
it's not legislated. It's a common.
Oh well, that I can't deserve. That it says that I can send it to an order, in which I didn't. But it's nothing I can do. My hands are tied.
I mean, that's the order that's been made. If there was an issue with it, you should have brought it up on the day.
I did say that I didn't agree that the rent was paid to that date.
According to the order, it's not the case. It was only.
Oh, there's no point in disputing it if it's in the order. It is what it is. But
I obviously can't remember because I hear a lot of these cases, so
yeah.
I can't recall what occurred, but that's the order that got made. You obviously still get rental arrears for the 287 plus the 11th and the 12th of January, so there'll still be an order for those of that amount of rent to be paid. I don't know as well. I can't recall what occurred in the hearing, but I may have made factual findings based on that documentary evidence that the rent, for example, I was satisfied that it was that proved Mr. Keenan's case on the day anyway. So I may have been, I don't know because I can't recall, but I may have been satisfied with that evidence on the particular day, because I had made a finding there in the first part of the order about how much is owed.
Yeah.
So if there's been a finding made, there's nothing I can do about it now. And you, 22nd, 29th, yeah, you'd be out of time to appeal it anyway to the Supreme Court. You've got, I think from memory, it's 30 days or 28 days. I mean, it wouldn't be worth it financially anyway.
Yeah.
The amount that you spend to appeal a few $100s would.
But yeah, I suppose it would be at the owner's discretion if he thinks he's being he's fairly watered, but we're out of time. That is what it is. I'm happy to accept the order for the change of locks and the rental arrears for whatever I can claim.
I'll make those orders now. Tribunal finds that the tenancy ended on the 12th of January 2016. The rent was paid to the 2nd of January. Well, I'm not going to make a finding that the tribunal, I'll change that slightly. Tribunal has previously because I've previously made a factual finding, so it may well be that I don't know because I can't recall, but I've already made a factual finding that that's the date.
Yeah, I'm definitely aware of your position. I mean, you need to make a finding on the evidence that you've got.
Well, the problem is I'm constrained by a finding already having been made, is the issue, I think, and then the order having been made as well. That's the problem. I can't keep on under the law. You can't. If the case has already been heard on a particular issue, you can't then go on.
Yeah.
Because otherwise parties would come back and re-litigate and you get different factual findings being made. So I find that the tenancy ended on the 12th of January 2016. The tribunal has previously found that rent was paid to the 2nd of January 2016. The claims for compensation in the application have been proved in the amount shown take into account fair wear and tear and depreciation. All other claims being dismissed. Arrears of rent allowed at 47870, so that's that amount plus the...
I'm sorry to interrupt, but it's common ground that amount's been paid that up until the 11th of February. It's only the 12th of February that's not paid.
We have received a payment from Mr. Keenan. It's on his ledger. His ledger is currently showing this paid to the 2nd of December with $490.63 on account. He did make a payment of $490.63 after the hearing, which we received as rent. So considering the courts say that he's paid to January, I don't know how to work out his paid to date. I don't know how you want to work it out, but we received a payment of $490.63 on the 10th of February, and it's on the summary proofs. So going off the order, it would be paid to the 22nd of January? Sorry, you've got my order. I can't remember what it said. Sorry, the tenant, 22nd of January, and then he would have $490.63 on account.
Didn't he move? No, he couldn't be the 22nd because he moved out before.
Of December, sorry. Whatever figure we're going off from the order from the 8th of January hearing.
I'm happy to clarify if you find out. Can.
What do you want to clarify, Mr. King?
There seems to be some confusion about dates and numbers and amounts paid. I'm happy to clarify that for you if you want me to.
What do you want to clarify?
That if you found today that I owe, that I was there, that I exited on the 12th, which I was disputing, then I only owe 1 day's rent.
No, you owe 2 days rent. You owe the 11th and the
No, I've paid to the 11th. I've paid, and I handed you evidence to show that I've paid to the 11th. If I may, the last order made says the rent at point 3, the rent, which is for $14.56 per calendar month, is paid to the 2nd of January 2016, and the rent owed to today's date is $287.22.
Yeah, to today's date, not including today's
That's
date.
right.
Not including the 11th.
And on that day you projected the amount that was payable up to and including the 11th of January, and you gave us that figure.
No,
you did. No, you did.
No, I did
No, you
not.
did. You couldn't put it in the order. No, I'm sorry. I was there. I was there.
Keenan,
I was there.
the order says what it says, and it says
I agree.
to today's date.
I agree.
That doesn't say including the 11th of January, it says to today's date.
I agree. The applicant and I have confirmed it's common ground that I've paid the amount of $490.63, I believe it was.
How much do you say you owe?
One day, the 12th of January. Of February. Of January, sorry. The 12th of January. Because we both agree, and I handed up evidence that I showed I've paid that amount.
So you say you owe $47.87.
Yes.
What do you say about that when he has paid $490?
Yeah, I'm not disputing the 490.63. So if we're going off the pay to date from the order dated 8th of January, so that order, does that specify that the tenant is paid to the 2nd of January, was it?
Yes.
Yeah, so he would now be paid to the 2nd of January with $490.63 on account.
So you say you owe $47.87.
Yes, and it's common ground.
It'll be a day. Right, so that'll be the amount then I'll award for the arrears because he's paid it off. Will be the $47.87 which you say you owe, Mr. Keenan. Tribunal finds that the tenancy ended on the 12th of January 2016. The tribunal has previously found that rent was paid to the 2nd of January 2016. Claims for compensation in the application have been approved in the amount shown, taking into account fair wear and tear and depreciation, all other claims being dismissed. Arrears of rent allowed at 47.87, keys and garage remains 473, total claim approved 520.87. Tribunal finds that the tenant has paid bond of 13.90, direct the RTBA to pay to the landlord 520.87, direct the RTBA to pay to the tenant 869.13. The tenant must reimburse the landlord the application fee of 59.80. Any order for arrears of rent made today includes all previous unsatisfied orders for arrears arising out of this tenancy.
I did also apply for payment of $75 for the VCAT attendance fee for today, which the owner is charged for my time.
I didn't see that.
Oh, it's on the application.
No, I didn't see that.
Oh, you did? Oh, sorry.
I did, and I've chosen not to award it because those kind of appearance fees, the costs in these kind of matters, we don't normally award.
Okay.
I'll hand that to you. Oh, and actually you've trusted me.